With regard to security fraud, one of the primary issue we see oftentimes, and probably more often on a state level than a federal, is what is a security? Because there are certain definitions of what constitutes a security. And a security may not be what you think it is. The classic example, of course, is a stock or a bond that's traded or even privately held. Those, without much question, are securities. But there are other forms of transactions where an individual may invest in a business that oftentimes is testified to by a representative of either the state or federal related SEC, that the entity actually is a security that you wouldn't otherwise think is a security. So instead of having a theft charge, you may have a theft charge, but you also may have a violation of state or federal security laws. And here again, that is driven depending on the amount. In state court, you may have a class 3 felony that in essence is a 4 to 12 year felony. And in federal court, again, you may have a statute that is applicable of 20 years. And that is driven by the federal sentencing guideline, which is a very complex computation dependent upon your involvement, your role in the offense, whether you were violating a trust, and how you were utilizing and gained access to the funds. So in securities fraud, where they normally start is, at least on the federal level, is an individual, whether it's a private investor, whether it's a public company representative, are contacted by a representative of the SEC wanting to take your statement and or a deposition. And the mistake that I often see when we're representing a businessman on what we'll call white collar crime is he hears from the SEC, and albeit he's very concerned, he doesn't view that as a criminal prosecution. That is the beginning of a criminal prosecution. And more often than not, when we represent that individual, we go with them to the SEC and we refuse to answer the question and invoke the Fifth Amendment, because his answer, albeit in a quasi-civil proceeding, that information ultimately will be turned over to the United States Attorney, who may institute a criminal proceeding. And what happens in those situations is you can have a civil proceeding instituted by the SEC, and at the same time or shortly thereafter, a criminal proceeding instituted by the U.S. Attorney's Office, which creates a whole other situation where you need expert counsel because you may be wishing to defend your civil case against a civil judgment, but be precluded from testifying, or you should not testify in the civil case because of a potential criminal prosecution. So oftentimes we're in a situation where there's a conflict in the legal advice, which may require more than one counsel, because what's in the civil interest of the client is not necessarily consistent with what's in the criminal interest of the same client.